your case, so be wary of that. All right, let's start off with, I don't know why it's out of order a little bit on my document, but Kenneth Harrison. Is Kenneth Harrison here? Seems to be weird though, that would be number one. Is this from the wrong page?
Actually, the original or the updated document?
Maybe I don't have the updated one. I printed it in the morning, so I might have the old one.
I was out Monday, so Valerie sent the initial docket. She might not put it in the correct.
All right. I know one came in, but I didn't print it this morning, so. Due date docket. All right. I'll use this one then. All right, Jaden Adams.
Y'all come forward. There's a blue X on the floor right here. You can come in, stand here, keep your hands out of your pockets when you're up here, please.
Give me just a second, Mr. Adams. All right, Mr. Adams, you're here in 26 CF 1177, charged with possession of more than 20 grams of marijuana. Mr. Maddox, you represent him?
Yes, sir, I do, Your Honor. Will enter a plea of not guilty at this time, demand trial by jury.
All right, and I'm just going to put everybody for August unless you tell me differently. Mr. Maddox, Ms. Rivers, Mr. Williams. August 24th at 1 o'clock will be your pretrial conference. Mr. Adams, be back on that date. Stay in touch with Mr. Maddox. All right, next is Donald Alford. Is Mr. Alford here?
He is not, Your Honor. He is in custody, I believe, in Walton County. He's being held on a violation of probation over there. So I'd ask the court just enter a not guilty plea today. I'll enter one on his behalf and demand trial by jury at this time.
All right, due to the fact that you waived his appearance, I'll go ahead and set him for August 26th at 9 a.m. since he's in custody currently.
Yes, Your Honor. We'll probably be able to resolve this, would be my guess.
Okay. And I think the main reason is keeping an ROR so he can go over to Walton County, right?
I would assume so.
Okay. All right. August 26th, 9 a.m. Close my docket. All right, next I've got Willard Alford.
Mr. Alford.
Mr. Alford's here.
Yes, sir.
26 CF 1167, charged with burglary with assault or battery.
Yes, Your Honor. Your Honor, we'll plead not guilty at this time, demand trial by jury.
Okay, information's been filed and handed to Mr. Alford. We'll put you on August 26th at 9 a.m. for purposes of pretrial conference. All right, Malik Arrington.
Barrington? Yes, sir. He's present and approaching, Your Honor.
All right, 26 CF 1183, and information's been filed charging him with introduction of contraband into a county detention facility. Mr. Maddox, you do represent Mr. Arrington.
I do, Your Honor. We'll enter a plea of not guilty at this time, demand trial by jury.
All right, it'll be August 24th at 1 o'clock for your pretrial conference. Mr. Arrington, be back on that date. Stay in touch with Mr. Maddox.
Thank you, sir.
Patrick Cannon.
We were on this case, Your Honor, but I do believe we filed a motion to withdraw. Let me know if you have the order, otherwise I'll make sure you have it.
I don't see, oh, there's the motion. I do, no, here's the order. Looks like it's just put in. Mr. Cannon here?
That I do not know. Patrick Cannon? See if we have a note from him, Your Honor.
I can do that.
Seven prior failures to appear. Got an ROR. Seven FTAs. Got an ROR. Reviewing his arrest report, it shows today's court date as 7:30 at 13:30 hours in the Crestview Courthouse.
And I have no notes, Your Honor.
Based on that, it's going to be a KPS no bond.
Oh, no, because you just signed the order, so it's.
I just signed the order.
Yes, sir, Your Honor.
All right, Jason Christmas. Mr. Christmas is present and approaching. This is 26 CF 1159. Information has been handed to Mr. Christmas. Mr. Christmas, make sure you go around the other side. Charging him with burglary of an unoccupied dwelling and resisting without violence. Mr.
Yes, sir,
Maddox?
Your Honor. One to plea of not guilty, demand trial by jury.
All right. Mr. Christmas, your court date's going to be August 24th at 1 p.m. We'll see you back on that date. Stay in touch with your attorney, Mr. Maddox. Randy Cooper.
Cooper?
Mr. Cooper is present and approaching in 26 CF 1155. And information's been filed and being handed to Mr. Cooper, charging him with felony petty theft, resisting a retail merchant, and resisting an officer without violence. Mr. Maddox?
Yes, Your Honor. One to plea of not guilty at this time, demand trial by jury.
All right, Mr. Cooper, you're going to come back on August 24th at 1 p.m. Stay in touch with your lawyer. Be back on that day.
Thanks, sir.
Pierce Crosby. Pierce Crosby is present and approaching in 26 CF 1150. He's just been handed information where he's charged with possession of a controlled substance and leaving the scene of an accident.
Yes, sir, Your Honor. Will enter plea of not guilty at this time, demand trial by jury.
All right, Mr. Crosby, it's going to be August 24th at 1 p.m. for your pretrial conference. Come back on that date. Stay in touch with Mr. Maddox.
Oh, was this the one you had a PTI on by chance? Offer for?
Hang on.
Might have been this one. I just want to make sure I don't miss it because I always tell people to take.
Crosby.
It was either a PTI or pleaded to misdemeanors. I just couldn't remember the case.
Well, I figured that out. Justin Cumby. I think he's an inmate.
Just take a seat right there for me. Get that figured out for you.
Yeah, I said that he could either plead to the PTI as charged, or he could plead to two misdemeanor or POP and leaving the scene
Okay.
with an 18-month probationary term and keep the withhold on both counts.
Yep. All right. Perfect.
All right, Mr. Cumby's here in 26 CF 1184. He's been handed information charging him with possession of controlled substance, trespass, and petty theft.
Yes, sir, Your Honor. We do have a resolution in this case. Sorry, there, fine. Right there. All right, Your Honor, we'll just briefly pass him so that I don't hold anybody up. I just got to get the state signature and confirm that everything's good to go.
Okay. All right, Mr. Cumby, we'll call you back up so they can get all the paperwork together, and then you can enter your plea today.
Thank you, sir.
All right, Rico Daniels. Mr. Daniels is present and approaching in 26 CF 1185. He's just been handed information charging him with burglary of an unoccupied dwelling and grand theft.
Yes, Your Honor, that's correct. One for plea of guilty and demand trial by jury at this time.
All right. Mr. Daniels, your next court date's going to be August 24th at 1 o'clock. Be back on that date. Stay in touch with Mr. Maddox.
Thank you.
All right, Angela Ferguson. Ms. Ferguson is present in 26 CF 1227. She's been handed an information charging her with possession of a controlled substance and possession of drug paraphernalia.
Yes, Your Honor. This time went to a plea of not guilty and demand trial by jury.
All right, August 24th, 1 o'clock. Stay in touch with Mr. Maddox. We'll see you back on that date. Kenneth Harrison. Is Kenneth Harrison here?
I believe he was here earlier, and that was the one we told him he was supposed to be back.
What do you look like?
Shannon Garrett.
All right, let's pass Mr. Harrison to see if he just stepped out or thought he wasn't supposed to be back until 2 o'clock, because we talked about a 2 o'clock docket maybe. But we'll recall him. If he's not here, then it's probably going to be a KPS. All right, Avian Harshaw. All right, Mr. Harshaw is present in 26 CF 1258. He's just been handed an information charging him with battery on a law enforcement officer.
Judge, I'll enter a plea of not guilty on Mr. Harshaw's behalf. Request 15 days free arraignment motions, trial by jury.
All right, Mr. Harshaw, this is Mr. Williams. Stay in touch with him. You're going to come back on August 24th at 1 p.m.
Thank you, sir.
Samuel Head. Mr. Head is here in 26 CF 1160. He's just been handed an information charging him with aggravated battery, grand theft auto, introduction of contraband, and possession of a controlled substance.
Judge, I'm going to enter a plea of not guilty on his behalf. 15 days free arraignment motions, trial by jury.
All right, Mr. Head, you're going to come back on August 26th at 9 a.m. for your pretrial conference. Thank you. All right, Ashley Kelly.
She's in custody. Island's here. That's the next one that's out of custody if you want.
Okay.
Clovis McClellan, 2026 CF 1162. Come on up, Mr. McClellan. Judge, he's already got a case set on the 24th docket. I'm sure you remember Mr. McClellan. We're going to enter a plea of not guilty on his behalf on this case. 15 days free arraignment motions, trial by jury. The court may want to set this with the other. We did a bond hearing.
I remember. I'm just trying to find his other cases. Looks like he's got a.
I say 824. It may be on, originally had been on for 826 probably.
He's also got a case in front of Judge Ward on the 17th. Why didn't we have that? All right, August 24th at 1 o'clock
Thank you, Judge.
to go along with 26 CF 81.
All right, sir.
All right, thank you. Now I've got Ms. Kelly here.
Ms. Kelly is present, 26 CF 1375. Information's been filed charging her with driving while license suspended as a third conviction or subsequent, as well as leaving the scene of an accident.
Judge, I'll enter a plea of not guilty on her behalf. 15 days free arraignment motions and trial by jury.
All right, August 26th at 9 a.m. for pretrial conference.
I'll come out and see you.
Okay,
I think she's got other cases too.
26 at 9 a.m.
okay.
All right, where are we at? Skylar Lewis.
Lewis?
Judge, this is Skylar Lewis, 2026-1187. We're going to enter a plea of not guilty on his behalf, request 15 days for pre-arraignment motions.
Okay, information's been filed charging him with battery by strangulation. He's received a copy. All right, August 26th at 9 a.m. for pretrial conference.
Come out and see you again once I get an answer to discuss.
All right, Dakota Madden, we already handled, right? As well as Masson Gill, Ann McClellan, Brian Miller.
Mr. Miller.
Mr. Miller is here in 26 CF 1222, charged by information with possession of a firearm by a convicted felon. He's been given a copy of that information.
Judge, I've been out to see Mr. Miller a couple of times. We discussed the case. We've got a negotiated plea offer and score sheet here.
Okay. So he's pleading to the min-man.
Yes, sir.
Mr. Miller, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth, please?
Brian Lee Miller, 8/16/1979.
All right, Mr. Miller, you're here in 26 CF 1222, where you're charged with possession of a firearm by a convicted felon, which is a second-degree felony and punishable by up to 15 years in state prison. Do you understand that?
Yes, sir.
There's also a $10,000 fine as a maximum and a 3-year minimum mandatory prison sentence. Do you understand that?
Yes, sir.
Have you had enough time to go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand and sign the agreement? All right, and it calls for that minimum mandatory of 3 years in Department of Corrections with credit for all time served, $515 court cost, $50 application fee, and a $100 PD fee. I would just send those to judgment for you. Is that what you want to do here today?
Yes, sir.
Have you had, do you need any more time to speak with your lawyer about this?
No, sir.
Are you satisfied with your lawyer's representation and advice in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I've read to you?
No, sir.
You understand by entering a plea, there won't be a trial of any kind.
Yes, sir.
You understand you're giving up your trial rights, which start on page 1 and go on to page 2 of the agreement you stated you understood and signed.
Yes, sir.
And you understand you're waiving any potential defenses that you may have.
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
It also calls for an adjudication of guilt, which means this would be a felony conviction. Do you understand that?
Yes, sir.
All right, and Mr. Miller, what is your plea to the possession of a firearm by a convicted felon?
No contest.
I'll accept your no contest plea is freely, voluntarily, knowingly given, adjudicate you guilty, sentence you to 3 years in Department of Corrections as a minimum mandatory sentence, credit for all time served, $515 court cost, $50 application fee, and a $100 PD fee. I'll send those to judgment to be collected against you, Mr. Miller. This is a guideline sentence, as it is a 3-year minimum mandatory and did not score. All right, I'll need your fingerprints, Mr. Miller, and then you have 30 days to appeal the judgment and sentence of the court.
Good luck to you, Mr. Miller.
All right, thank you, sir. All right. Is it Hoi Nguyen?
Judge,
The
we
wind.
arranged for an interpreter,
You did?
my understanding, yes, sir.
How so, like on Zoom or what?
That I don't know. I just know that I asked her around, and he sent the correspondence back that she had arranged for one.
Vietnamese interpreter, here we go.
We had tried to use language line in the office. He's got a friend that accompanies him that translated briefly for the office.
Okay.
Yeah,
I'm going to invite the interpreter in now.
Ah, here we go.
Ms. Nguyen, can you hear me?
Yes, good afternoon, Your Honor.
Okay, can you raise your right hand? Do you swear to fairly and clearly interpret all commentary during the course of this case?
I do.
Okay. All right, we're here for Mr. Nguyen.
Thì ngày hôm nay mình ra đây cho vụ kiện của ông Nguyễn.
And it's case number 26CF1212.
Số vụ kiện của ông ấy là 26 CS 1212.
He's charged by information with aggravated battery with great bodily harm.
Thì ông bị cáo buộc dựa theo bản cáo trạng là hành hung cấp độ gia trọng với là thương tích nghiêm trọng đến cơ thể.
Okay, Mr. Williams, what would you like to do today?
I'm going to enter a plea of not guilty on
Luật
his
sư William
behalf.
muốn làm gì?
15 days for pre-arraignment motions, trial by jury.
One moment, forgive the interpreter counsel. Would counsel speak directly to the mic?
Yes.
Thank you.
Go ahead.
Plea of not guilty, 15 days for pre-arraignment motions, trial by jury.
Thì ngày hôm nay chúng tôi đưa ra lời khai không có tội và có kiến nghị tiền xét xử 15 ngày, trong vòng 15 ngày, và chúng tôi yêu cầu phiên xét xử có bồi thẩm đoàn sau đó.
All right, we'll see you back for a pretrial conference on August 24th at 1 p.m.
Vậy ngày 24 tháng 8, 1 giờ là mình quay lại cho một cái phiên tòa tiền xử.
Make sure you set up for an interpreter for that date, Mr. Williams.
Yes, sir.
Thì luật sư William phải gọi văn phòng thông dịch để mà đặt thông dịch viên cho ngày hôm đó.
All right, thank you.
Thank you very much.
Thank you, John.
All right, thank you. Have a great day.
Thank you, thank you.
All right, next is going to be Bennett Page. Mr. Page is present. Ms. Rivers, I think this is your first one. This is 26 CF 1264, and information's been filed and given to Mr. Page, charging him with possession of a controlled substance.
Your Honor, we're going to enter not guilty plea and request trial by jury.
All right, pretrial conference date will be August 26th at 9 a.m. We'll see you back on that date, Mr. Page.
Your Honor, are you tracking that it's being?
Oh. Good thing there's no notes on it.
Yes, Your
All right, next is going to be David Prue. Mr. Prue is present and approaching from the back in 26 CF 1042.
Did you get our motion to withdraw due to a conflict?
I didn't see it until just now. All right, Mr. Prue, so the public defender has filed a motion to withdraw due to a conflict issue, so I'm going to appoint you to the Regional Office of Conflict Counsel. I'll enter a plea of not guilty on your behalf. You'll have a little bit of a different court date than the public defender client, so you're going to be August 24th at 9 a.m. Mr. Kleins is going to be your lawyer. They're giving you a card right now with his information on it. Reach out to him so you can have an appointment before that August date. All right, thank you, Mr. Prue. Have a good day. Christopher Renfro.
Renfro.
All right, Mr. Renfro is here in 26 CF 1244. He's been charged by information with dealing in stolen property, conspiracy to commit a felony, and fraudulent use of a credit card. Ms. Rivers.
Your Honor, we're going to enter not guilty plea and request trial by jury.
All right, August 26th, 9 a.m. for pretrial conference. All right, Michael Sco. Always a pleasure. All right, Mr. Sco, you're here in 26 CF 1245. You've been handed information charging you with accessory after the fact to a felony and reckless driving. Do you understand those charges?
Yes, sir.
All right, do you plan to hire your own lawyer, or do you want me to talk to you about appointing one?
Try to get a court appointment.
Okay. Y'all handled the other case today, right, Scott?
Sorry, Your Honor.
What was the one this morning, Scott? He entered a plea. Guy from Alabama. Co-defendant in this case, right? Ethan Scott, I think. Is that right? Yeah. We handled this case this morning. I just want to make sure I get you the right attorney.
Brandy Merrifield.
Oh, Brandy had it? Okay. All right, so can you afford an attorney, Mr. Sco?
I mean, I'd like to court appoint one if I could.
That's not the question.
I
Do
can
you-
afford one.
You can afford one? Well, then you have to fill out the application to see if you qualify, because if you afford one, I can't just give you an attorney because you don't want to pay for one. All right, so I'm going to give you the form, and you can fill that out, turn it into the clerk's office on the first floor, and then that will determine whether or not you're appointed a lawyer. In the meantime, I'm going to enter a plea of not guilty for you, and I'm going to put you on the August 24th at 9 a.m. pretrial conference date. If you hire a lawyer, come back on that date. If you ultimately are appointed a public defender, why don't we just put them on 1 o'clock, just to make sure? I'll put you on the 1 o'clock docket that day, August 24th. But if you're appointed a public defender, you'll remain on the PD docket for that day. Otherwise, if you get denied, you can hire your own lawyer. Otherwise, we'll talk about it on that day. All right, August 24th, 1 o'clock. Fill that out, turn it in before you leave the courthouse today.
Yes, sir.
All right, thank you. All right, Krista Spears.
Your Honor, this is Krista Spears before the court on 26 CF 1137. I had filed a motion for direct release because Ms. Spears had been in custody since June 10th, 2026, without an information filed, and more than 40 days had passed. The state, of course, now has filed an information for today, but we're still asking that the court release her on the ROR bond so she can pursue this matter from the outside.
All right, state want to be heard on that?
Well, just give me one moment, Judge.
Looks like she was arrested on or about June 10th?
She had her first appearance on June 10th,
June
Your Honor.
10th, so probably arrested on the 9th.
9th, yes, Your Honor.
And then the information wasn't filed until July 27th,
That's correct, after I filed this motion, Your Honor.
about an hour. What I'd like to find out is if the state maybe didn't find out about the case until then.
Well, actually, the state got it on a delay. I will say this, the state got it on a delay. I did file the information, and I can tell you the date that I filed the information.
It's the same day as the motion that was filed,
Through the
about an hour later.
No. I mean, I did my part to file the information on July 18th or 19th. Hang on one second.
Well, I'm not sure why it took so long to actually get
Right,
filed.
that's, well, and I can't tell you that. That's the other side of it, is I don't know why it would have taken longer, but you filed,
She's currently on a $2,000 cash or professional.
And she's been unable to make that bond, Your Honor.
it says I filed it on 7/20 at 4:50 PM is when I completed in,
I understand that, Mr. Mall, but it doesn't get filed, that's the operative issue.
right.
And that's still at 40 days. So,
I'm just trying to pull up the rule of procedure because I think it's recently changed and
3.134.
I got it. Thanks. Changed July of last year, but it feels like it's been, let's see. All right, I'm going to release her on her own recognizance at this point. On this case. I will just kind of remind everyone that 3.134 states The defendant remains uncharged. The court on the 30th day and with notice to the state must order the defendant automatically be released on their 33rd day unless the state files formal charges by that date. But it has to be brought to the court's attention. I can't track the 900 or so criminal cases in my head. So just bring it up and I'll certainly address them. And I understand also the state's concerns about when they receive information, but I can only work based on what the rules of procedure say.
This is one of those ones I think just got through the system in such a sideways thing that it didn't get filed on correctly.
I understand, Mr. Mall, but I still got to work within the rules.
Yes, sir.
ROR for Ms. Spears.
And Your Honor, her next court date would be?
August 24th, 1 o'clock. Make sure you're here. Plea entered of not guilty.
Yes, Your Honor.
All right. Tesla Talbert. Talbert is present in 26 CF 1154. Information's been handed to her, charging her with felony petty theft.
Your Honor, we reached an agreement in the matter. May I approach?
Yes. Thank you. $164 days in jail. It's as charged.
Yes, Your Honor.
Is there a score sheet?
I can get you one.
All right, please.
Talbert.
I'm assuming you know what the score would have been, Ms. Rivers. Is it going to be a downward departure in some way?
I don't believe so, Your Honor.
No, it's not.
Okay. All right, Ms. Talbert, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, can you state your full name and date of birth, please?
Cecily Cheyenne, August 10, 2000.
All right, Ms. Talbert, as stated, you're here in 26 CF 1154, charged with felony petty theft, which is a third-degree felony and punishable by up to 5 years in state prison. Do you understand that?
Yes, Your Honor.
I've been handed a plea and sentencing agreement between you and the state that calls for you to plea as charged, so, be an adjudication of guilt, so it's a felony conviction. You're to serve 164 days in Okaloosa County Jail with credit for time served, $515 in court costs, $100 PD fee, a $50 application fee. I can give you 90 days from your release to go ahead and pay those or set up a payment plan. Is that what you want to do here today?
You have to.
Yes. Yes, okay. If you just move the microphone back towards her, too. All right, is there a reason for 164?
I think I did. I think I was at the house doing this. I think I totaled it up in my head and it was today. I think that's why I did it.
Okay, well, I don't know that.
I don't know why I picked it.
You're trusting Mr. Mall's math.
I believe she does have a little bit longer.
Okay. All right, Ms. Talbert, have you had enough time to go over this agreement with your lawyer?
Yes, Your Honor.
Did you understand and sign the agreement?
Yes, Your Honor.
And are you satisfied with your lawyer's advice and representation in this case?
Yes, Your Honor.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Are you currently suffering from any mental health issues?
No, Your Honor.
Has anyone forced, pressured, or threatened you in any way on this plea?
No, Your Honor.
Has anyone promised you anything in return for your plea?
No, Your Honor.
And do you understand by entering a plea, there won't be a trial of any kind?
Yes, Your Honor.
And you understand that you're giving up your trial rights, which are on page 1 and going on to page 2 of the agreement that you stated you understood and signed?
Yes, Your Honor.
And you understand you're waiving any potential defenses that you may have?
Yes, Your Honor.
And you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, Your Honor.
All right, and Ms. Talbert, what is your plea to the felony petty theft?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. Sentence you to 164 days in county jail with credit for time served. It's my understanding from both lawyers, they think you've got credit for time served, but I can't make that determination, and it's not in front of me. That's for the jail to make that determination. $515 in court costs, $100 PD fee, and $50 application fee. I'll give you 90 days from your release to set up a payment plan or pay those costs. You do only score 13.60 points, so this is a guideline sentence. I just need your fingerprints, Ms. Talbert, because it is a felony conviction. And you have 30 days to appeal the judgment and sentence of the court.
Okay, thank you, Your Honor.
Thank you. 164 days. I just wonder why it's just not time served. All right, James Tilburg. No, he's not. Who's this? Mr. Tilburg is here in 26 CF 1224. He's just been handed information charging him with fleeing flee or attempt to elude law enforcement with lights and siren, resisting without violence, possession of a firearm or ammunition while subject to a domestic violence injunction, and leaving the scene of an accident.
Your Honor, we're going to enter a not guilty plea and request trial by jury.
All right, Mr. Tilburg, you're going to come back on August 24th at 1 o'clock. Excuse me. Stay in touch with Ms. Rivers, and we'll see you back on that date. Kevin Wilkes. I have Wilkes.
Whoops.
All right, Mr. Wilkes is present in 26 CF 1148. He's just been handed a copy of his information charging him with possession of a controlled substance. Mr. Wilkes, you don't currently have a lawyer. Do you plan to hire one, or would you like me to speak with you about appointing one? Can you afford a lawyer?
Well, sir, I was trying to resolve the issue today, though.
Does the state have an offer?
Is it Williams?
Wilkes.
Wilkes, okay. The state's offer today was guilty or no contest, withhold of adjudication, 2 years of probation, that he paid the $615 in court costs, have a substance abuse evaluation, and any recommended treatments. And maintain gainful employment, and if he's not gainfully employed, that he put in 5 applications per week.
So it's another case.
He has another case?
He did. He got 90 days jail and adjudicated guilty on that one. That was back in January. It says reopened, but I think it should be closed. All right, what do you want to do, Mr. Wilkes?
Take a plea.
Okay. Do we have a plea form from Mr. Wilkes?
No, I do not.
I can give him one, Judge.
You know, stuff here that a VOP.
Can someone go over the plea form with him quickly? I won't
Yes, it's-
charge him if it's not necessary.
Yes, Your Honor.
All right. Mr. Wilkes, someone's going to come back and talk to you about the plea form, and then we'll recall you back later today.
Okay, thank you.
Thank you. All right. Is that everybody on the docket?
It is, but I know Mr. Harrison, Kenneth Harrison showed up, and I think we asked Aaliyah Thomas.
There was a written plea of not
Oh,
guilty.
okay.
Oh, it wasn't on that docket I had. All right, Mr. Harrison? All right, Mr. Harrison, you've just been handed an information, which is your charging document. In 26 CF 1236, you're charged with aggravated assault, domestic violence, battery, criminal mischief, and reckless driving. Do you understand those charges? All right. Can you afford an attorney to represent you in this case?
No, sir.
All right. I'm going to have you fill out the application form and go turn it in on the first floor before you leave here today, but I'll provisionally appoint the public defender's office. It's Mr. Williams who's coming up from behind you. You have to fill that out and turn it in today, otherwise I may remove him from your case.
Understood.
Mr. Williams?
Judge, I'll enter a plea of not guilty on his behalf, 15 days pre-arraignment motions and trial by jury.
All right, we'll see you back on August 24th at 1 PM. Stay in touch with Mr. Williams. Make sure you fill out that application and turn it in downstairs, first floor clerk's office. All right, I think that's everybody.
Your Honor, I'm sending in Mr. Carnley's proposed bond order now.
Okay, I'll take a look at it. All right, sir, you are?
My name is Reed Haley. I'm with the Office of Statewide Prosecution.
Okay, and who do you have?
I have Marvin Thompson, should be 26 CF 1274.
Give me the case number again.
It should be 26 CF 1274.
1274. This is in front of Judge Stone. When was it transferred?
The notice that I had me here.
Yeah, I understand. I'm trying to find out what the problem happened. I see the notice that went to Mr. Thompson in Tallahassee. Information was filed.
The only other thing I would note, Your Honor, is I haven't been getting served with anything, so.
And I see you filed a notice of appearance, because I just looked at it.
Sir.
Which includes your email address as far as, says provide all court filings to. Who represents him? PD. Y'all see an order transferring it? Because the original notice to appear has today's date in front of me, but it says it's assigned to Judge Stone in Fort Walton.
Judge, so I see a deleted hearing, so it looks like the clerk who sent the notice may have originally put in the wrong courthouse and then deleted it and put in the new courthouse. I'm not sure who it was, but it is showing today's date and time in front of you under deleted hearings.
Mr. Haley, right?
Yes, sir.
So despite the relatively small size of our county, we actually have two different courthouses, one in the north and one in the south.
Did I come to the wrong courthouse?
No, you didn't. You came to where you were told to go. But, so we separate cases based on where they occur, basically north or south of an imaginary line somewhere around Duke Field. And so it looks like your case has been assigned to Judge Stone in the south end. I can't seem to find why that happened or when, other than what the clerk just told us as far as there was some deleted hearing that I don't remember being a part of.
Got it.
But the problem is you're also not receiving copies of things that are being filed in your case. But frankly, I don't see anything that says when any other court date would have been set, other than it now has a pretrial conference date set for 14 September at 9 a.m. in front of Judge Stone.
All right, well, it's good to know that so it's at the other courthouse next time?
It'll be in Fort Walton.
Fort Walton, okay.
What you may want to do is contact Judge Stone's office and find out if there's any way you can appear by Zoom, if there's nothing major is going to happen, or if one of your local state attorney colleagues wants to cover to save you the trip from Tallahassee. I hate that too, because it's easier to get to my courthouse than it is to Judge Stone's courthouse, because we're right here on I-10.
Right.
When you're coming from Tallahassee, but the only thing I can, in looking through the actual charges, it appears the only thing that happened that I found so far that happened in Okaloosa County happened in the south end, so that's why it's been assigned down there. And frankly, we try to make sure things end up in the right site that they should. But it's not like in a criminal case, you file that situs form like we do in civil, where people just, a lot of times, just check whatever box they feel like. And that's why I end up with a foreclosure from Destin when I'm in Crestview. But it looks like that's when you're set for next. Mr. Thompson is represented by the Public Defender's Office. It's listed as Jason McKinney, who is a South End Public Defender. But your next court date would be September 14th at 9 a.m. for pretrial conference. Well, hold on a second. Let's make sure that's right. So we all do the same kind of cadence as to how our court dates work. We split up our pretrials Mondays out of custody, Wednesdays are in custody. Do we know if he's in custody by any chance?
I don't believe he is, Your Honor.
Okay. I'm just wondering why it says 9 a.m. though, then, because Judge Stone does it the same way, right? 1 o'clock would be public defender cases, and 9 o'clock, you're not sure? He sets them all at 9 o'clock? So that means everyone sits there all day? It's 9 o'clock.
Cool.
What I would do is check in with court security when you get there to tell them that you're from statewide and that you're there for that case. And that way, maybe they'll call it up right away, as opposed to have you sitting there. Or at least you can kind of get up, there's a sign-up sheet for private lawyers, but if you put your name on there, typically we take those as well. Because if you're here for one case from Tallahassee, we want to make you sit here for as
I
long as we made you do that today. But just bring that up with court security or contact Judge Stone's office ahead of time, just to make sure you're not in a situation where you're spending more time than you need to here. Although it's a great place to visit, you probably would rather get back to your office.
I've visited here before, and it's been great, but,
Okay.
but I appreciate it. Thanks for getting me straightened out.
Yeah, sorry about that, and I would contact the clerk's office to make sure, maybe even while you're here, stop by the first floor to make sure that you're getting emails and things that are being filed in the case. That probably would have fixed the part of the problem, but as you know, I don't have any control over how the clerk's office runs.
I understand.
All right, thank you, sir.
I appreciate it. Thank you.
Travel safe back. Mr. Cobb?
Judge, I went over the plea
Maddox.
form with Mr. Wilkes, word for word. He does still intend to enter the plea.
Okay. Is he out?
Anybody lined up?
Got Shannon Gallardo and Justin Cumby.
The only thing we have.
Hold on. Go ahead.
CI on Zoom with.
With Mr. Bryan, yeah.
You can do that.
So they're an hour ahead of us, so. I know
All right.
Those classification officers don't use.
I'll bring him in. Mr. Cobb, come on up.
And then you think you want to handle it?
I'm going to try and empty it out a little bit in here. All right, Mr. Bryan, can you hear me okay? I can't hear you. There it goes. It's a little better, but it's kind of hard to hear. All right, Mr. Cobb, we're here for Mr. Bryan's case, and this is going to be 2018 CF 1425. We're here on status regarding the motion for new trial and resentencing.
Yes, sir. I spoke with Mr. Bryan yesterday. I spoke with Mr. Muller yesterday as well. And I think I emailed Your Honor about what the issues are. Of course, he's here for resentencing and then a motion for new trial. And it's my understanding that if the resentencing goes in accordance with what I think the DCA opinion suggests, there wouldn't be a need to have the motion for new trial. Mr. Bryan would withdraw that. I spoke to the state about the sentencing parameters.
Okay.
And the state doesn't have any objection to the court sentencing Mr. Bryan to 10 years concurrent on everything.
So let me make sure I understand that, because in reading through the DCA's opinion again yesterday, it makes mention of how Mr. Bryan was serving a 30-year sentence at the time that this incident happened, right?
Right, and he still is serving that sentence.
And I understand that he's pretty close to release on that, is he not? Relatively.
Mr. Bryan, how close are you to being released on your original 30-year sentence?
Are you speaking to me, sir?
Yes,
I
sir.
am.
Make sure you speak into the microphone.
Sorry.
Yeah, I could barely hear what's going on.
Yeah, your 30-year sentence that you received, not the sentence in Okaloosa County, but your original 30-year sentence, how long along the way are you to completing that?
The max out is 2032, and with game time and 85%, I could somewhere along in there
Okay, 2032?
is the max out.
Okay.
I'm looking at it, the 30-year sentence was given in February of 2003. Obviously, I don't know that's from Broward County. I don't know what he may have received for credit for time served at that point. I guess my concern is What your email seemed to indicate that was sent yesterday is the 10 years concurrent for the charges that he has here. But what I didn't read is, would that be concurrent or consecutive to the time he was serving at the time of these offenses?
Well, it's really up to the discretion of the court. I don't think if you made it consecutive to his original, it would be a legal sentence. Of course, we would ask the court to make it concurrent, but the parameters of the DC opinion that I understood was 10 years. I don't know about whether it's consecutive or concurrent to his Marion County case.
Well, I guess with what he's charged with in this case, which is 4 counts of battery on a corrections officer, I think there's 1 misdemeanor count about taking away the pepper spray. But if I do concurrent with the sentence he's already serving, then basically that's assigned to inmates that they can do whatever they want while doing a 30-year sentence, and they'll just get concurrent time. So what's the real punishment?
I understand.
I'm not saying I've made that decision, but I want that to certainly be an understanding between what you and the state have talked about as far as these cases or these charges being run concurrent, the 4 different counts with each other, but whether or not they're concurrent or consecutive to the sentence he's already serving on something else from another county, I don't know if that changes Mr. Bryan's feeling on as to whether or not he wants to go forward on his motion for new trial.
Inquire really quick. Mr. Bryan, did you hear the judge, what he said? He doesn't know if he wants to do your 10-year sentence here consecutive to your 30-year sentence or run it concurrent. My question to you is, if the judge sentenced you to 10 years concurrent to your Marion County sentence, would you still be willing to withdraw your motion for a new trial, or would you want to still go forward with that motion?
I think it's
I thought we
Broward.
had
Broward, yeah.
I thought we had a agreement. The agreement is 10 years concurrent with the Broward case, and everything is settled.
No, sir.
That's what I was under opinion.
Yeah, the agreement was to be resentenced in accordance with the DCA opinion, which was that all your cases here in Okaloosa would run concurrent. The question is whether it should be concurrent with your Broward County case or consecutive.
Yes,
That's up to the
That's
judge.
at the judge's discretion. He would be helping me out, but I have a strong motion in front of the court. I'm trying to resolve all this. To me, the court has to grant me a new trial. He cannot review the trial issues because he wasn't the sitting judge. Therefore, I have to be granted a new trial. So if y'all want to make a agreement with 10 years concurrent, I'll go for that. If not, we'll just do the motion for a new trial, and I'll get a new trial.
I don't want you to try to negotiate and tell the court what it needs to do. You should not do that.
I'll make sure it's clear. The court's not negotiating with anyone at
All right,
this point.
thank you, Your Honor. And I guess he is right with regards to the motion for a new trial. Can that be heard before you, or does it have to be heard before the original judge? But the original judge is no longer on the bench, so.
Then it goes in front of whoever is in that division. I don't think it's to be treated really any differently than if I just switched divisions.
I think you're right about that. I think he thinks that since Judge Flowers is no longer on the bench, he automatically gets a win, but that's not the case.
I don't know what the issues at this point of the motion for the new trial are, because this is about the 10th or 12th time we've been here, and I've prepared for it in the past, and today was just status, so I haven't reread it. So I don't know what the issues are and whether or not that would be an issue to be addressed. But what's in front of me today is that the state seems to be willing that he can get basically maxed out but concurrent on his charges in Okaloosa County. My question is there an agreement those would run concurrent with his previous sentence from Broward County or not?
No, sir, I did not have that agreement with Mr. Mull.
And Mr. Mall is shaking his head, that's not part of the agreement.
Right.
Okay.
So really, with regards to what the DCA kicked back to us, you could sentence him however you want to in accordance with that DCA.
Well, I have to do the motion for new trial first.
Right. Yeah, that's what we're trying to avoid. So it looks like we
I
probably
understand that.
need to get him transported here and, I guess, do the motion for a new trial first. I was trying to wrap it all up today, but it's all right if we.
I understand, Mr. Cobb, but if there's an agreement on the issue, we'll talk about that. If there's not an agreement, I'm not going to tell people what I'm going to do until I hear everything.
Yes, sir, I understand.
Otherwise, we can bring Mr. Bryan back and have the motion for new trial hearing. And if I grant that, there'll be a new trial. If I deny that, we can go straight to sentencing.
Yes, sir. Do you understand that, Mr. Bryan? Sir, we're gonna.
What is the outcome? What is going on?
Well, I'm going to file a motion to have you transported to Okaloosa County so we can have your hearing on your motion for a new trial, okay?
Okay, so what's the point of today?
Just a status.
Okay.
All right.
All right. We'll have them transported and we'll have it heard. And again, I just haven't, I know I read the motion for new trial quite some time ago, but I don't remember all the issues of it because we've come back for these types of days repeatedly since, so.
You want me to contact Ms. Rhodes for a date and then prepare a motion order, or just contact?
We can give you a date if you'd like to just get it set.
Let me go grab my calendar.
Yes,
really
sir.
quick. Okay, Judge, ready?
Yes, sir. So how much time do you think you'd want before having that hearing?
Wait.
You speaking to me or my?
I was speaking to Mr. Cobb, but
Probably
obviously, one of my concerns with Mr. Bryan has been when he's been transported sometimes, he's told us that he wasn't able to bring his legal documents that he wanted to have with him. So I just want to make sure he's transported in the order that you send over indicates that he's to be able to bring those things with him.
I'll prepare it so that that language is included for sure.
Okay,
Maybe 6 weeks,
okay.
enough to get everything filed and transported, and then I can get him here earlier so I can discuss it with him, and I'll word it that way, so.
Work week. All right, I can either do September 10th, would be just about 6 weeks, I think. 1, 2, 3, 4, 5, 6, yeah, September 10th.
I'm available.
Mr. Sheik, is this
I'll be
you?
available, Your Honor.
All right, let's put September 10th at 2 PM for purposes of the hearing on the motion for new trial.
Your Honor.
Yes,
May I ask,
Mr.
May I ask that I do a Zoom hearing? I'm really tired of coming I'm in South Florida now. It's getting real repetitive coming all the way to Okaloosa.
Well, this is what I would do, Mr. Cobb, if you want to discuss that with Mr. Bryan. Again, I don't remember the entirety of the motion that we're here on status. If y'all want to talk about it, and if he feels he wants to not be here, if he's going to testify, I'd like him to be here, but I don't know what the circumstances are of the motion for retrial are at this point, or for motion for new trial.
Well, I think the 6 weeks that you've given me, it gives me enough time to talk with him to figure that out, and then file the appropriate motion, either to have him transported or via Zoom.
But I'll just tell you, Mr. Bryan, if we're in the middle of a hearing and you're not here, you're on Zoom, that you wouldn't really be able to communicate with your lawyer other than through the Zoom, right? I mean, I could potentially send you to a breakout room and send you out to the hall, Mr. Cobb, so you can talk to him without me present. I just want to make sure that you know if you're not sitting next to your lawyer, you're not going to be able to communicate with him very well during the course of what would appear to be a very important hearing for you.
Just do the transport, sir.
That's fine.
I'm waiting for this for a while.
I'll let you discuss it with Mr. Cobb, and if y'all want to file a motion to appear remotely, I'll consider it based on what you tell me.
Thank you, Your Honor.
Otherwise, September 10th at 2 o'clock.
If I may, Your Honor, just,
Yes.
and you don't have to answer now, but just for when we talk, if the motion that the defendant put in there, if you're accepting all of that, or if there's any changes, just please let us know on the actual motion.
Will do.
All right.
Thank you, Judge.
Thank you. Thank you, Mr. Bryan.
Yes, sir.
Have a good day.
You too.
All right, have y'all talked about who might be a shorter thing? Go ahead.
Got two brief pleas, Your Honor.
Okay, let's
If I
take,
could.
let's take those.
Mr. Gallardo?
Mr. Maddox, are you ready on Cumbie and Wilkes?
Cumbie, yes. Wilkes, sure. I know Mr. Mall was filling, I didn't fill out the plea form because I just went over it with the court. Your Honor, this is Mr. Gallardo, 20 CF 128 and 24 CF 545. We're here for either plea or an evidentiary hearing. Mr. Gallardo has elected to plea. The agreed upon sentence will be 14 months, Department of Corrections concurrent with credit for all time served, Your Honor. It is going to be a downward departure based on legitimate uncoerced plea bargain.
All right, do you have a plea form?
Yes, sir, I do.
You have a guidelines too?
Mr. Mall is printing it, but he's forced 20-something months.
Mr. Mall, do you agree with the downward departure based on uncoerced legitimate plea bargain?
Yes, Your Honor.
All right, Mr. Gallardo, can you raise your right hand? Do you swear or affirm the truth, the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Shannon Orlando Gallardo, 11678.
Okay, Mr. Gallardo, you're here in 20 CF 128 and 24 CF 545, both of which are violations of probation. Do you understand that?
Yes, sir.
I've been given a plea form between you and the state that would call for you to admit your violation of probation. Your probation will be revoked and terminated. You get 14 months Department of Corrections with credit for all time served. Your sentence is to run concurrently. $100 VOP fee for each case. $100 cost of defense in each case, $50 application fee, and just the 20 CF 128. Be adjudicated guilty on all counts in both cases, cost of judgment upon your admission of the violation. Is that your understanding of the agreement?
Yes, sir.
Have you had enough time to go over this agreement with your lawyer?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I just read to you?
No, sir.
And you understand by entering admission to these violations of probation, there won't be a hearing where the state would have to prove how you violated your probation.
Yes, sir.
In fact, we're here for that hearing today, but you're entering a plea.
Yes, sir.
All right. And do you understand you're waiving any potential defenses?
Yes, sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right, and what is your plea to the violations of probation?
Yes,
Are you admitting or denying them?
Admitting.
I'll accept your admission in both cases as freely, voluntarily, knowingly given, revoke and terminate your probation, adjudicate you guilty, both cases, all counts, 14 months Department of Corrections with credit for all time served. Your sentences will run concurrently, $100 VOP fee in each case, $100 cost of defense in each case, a $50 application fee, and 20 CF 128. And your costs will all go to judgment. Is there anything I missed?
No, Your Honor.
Okay. This is a downward departure based on an uncoerced legitimate plea bargain, is what I've been told. Do we need fingerprints, or do y'all have them?
We have them.
All right, we have your fingerprints, so we don't need those. Mr. Gallardo, you have 30 days to appeal the judgment and sentence of the court, and I believe he'll be taken into custody at this time.
Yes, Your Honor.
This way.
Yes, sir.
Good luck, Mr. Gallardo. Judge, here are the guidelines. You just scored 20.7 points. I have no objection.
Thank you. Ms. Rivers?
I may have skipped one, and I just wanted to, probation pointed it out, I just wanted to touch base. Aaliyah Thomas,
I think there was a written plea of not guilty also on that
we
one.
did, Your Honor, and we did a waiver.
Okay, I think it was just taken off the docket for that reason.
Thank you, Your Honor.
All right, Mr. Maddox, what else did you have?
Justin Cumby.
He's on the 1:30 docket.
Yes, Your Honor. 2 years of probation along with the specified terms if I may approach.
Yes.
Drug pending probation, I should say. It's a guideline sentence, Your Honor. Where she attached.
Have the form. Which one does she have? furlough. Yeah.
Judge, I'm not going to sign this plea agreement unless you provisionally appointed us. I went over it with him as a friend of the court. Obviously, I didn't hear if you provisionally appointed us or not. If you did, I'll sign it.
All right. I'll provisionally appoint you. I think it's fine. I was just trying to save him the application fee and everything.
Yeah, that's why I said I. So I did go over everything in this form with Mr. Wilkes. I went over the case very briefly with him. I'm obviously not familiar with it, but that being said, he did want to enter this plea. Mr. Ball, could we do a withhold since it's considered felony?
I thought he had a felony, that's why.
I think it was,
I am fine with a withhold if it's his first one.
Not that I see in the score sheet. All prior misdemeanors that I see.
I think he had a felony case, but he pled to misdemeanors.
Yeah, we'll do a withhold.
Cross that out.
That was 24 CF 2906. He had a VOP. Yes, in that case, he pled to a misdemeanor in felony court, so he doesn't have a prior felony. At least not in that case.
Yes, sir, Your Honor. I've reviewed this score sheet with Mr. Wilkes. He had no objections to it, therefore I have no objections to it.
I just, normally I wouldn't go out of my way to say anything that I find in someone's record, but since I may have said something that indicates that I think that this is his first felony, I do see in 2018-269, there is a carrying concealed firearm charge for which he got a withhold. And I'm not trying to bring that up to cause any issues, I'm simply bringing that up because of what I said. It made it sound like I was indicating he had no felony priors.
For the record, the state is now aware of that. I thought I had seen one, that's why I initially said, I am fine leaving it exactly like it is as a withhold.
Okay.
It's a second withhold.
So it's still a withhold, Mr. Wilkes.
He doesn't violate.
All right, Mr. Wilkes, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. Wilkes, can you state your full name and date of birth, please?
Kevin LeVon Wilkes, 10/02/1978.
All right, Mr. Wilkes, you're here in 26 CT 1148, where you're charged with possession of a controlled substance, which is a third-degree felony punishable about 5 years in state prison. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement between you and the state that would call for you to plea as charged, be a withhold of adjudication, 2 years probation, 615 court costs, substance abuse evaluation, complete any treatment, and maintain employment is what will be required during the course of your probation. Is that what you want to do today?
Yes, sir.
All right, I provisionally appointed you a public defender for purposes of this plea today. Do you need more time to communicate with him?
No, sir.
Do you understand he hasn't had a chance to investigate your case to see if there's any weaknesses in it that you could exploit?
Yes.
Yes. Do you understand that you'd be waiving any potential defenses that you may have?
Yes, sir.
And do you understand you're giving up your trial rights that are on page 2 of that agreement that you reviewed and signed?
Yes, sir.
All right. Do you need more time to speak with Mr. Maddox from the Public Defender's Office?
No, sir.
Okay. And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I just read?
No, sir.
And do you understand that you'd be giving up your right to a trial?
Yes, sir.
And you'd be giving up your right to have an attorney investigate your case and determine
Yes,
if
sir.
you have any defenses?
Yes, sir.
You have to just wait for me to finish, so that way I know what you're agreeing to. And do you understand that you're waiving any potential defenses that you may have?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation
Yes,
or
sir.
exclusion from the country?
Yes, sir.
Okay. And what is your plea to the possession of controlled substance?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. Withhold adjudication, 2 years probation, 615 court costs, complete a substance abuse evaluation, and any recommended treatment. You must maintain employment during the course of your probation.
Yes,
All
sir.
right, Mr. Wilkes, I need you to speak with probation, who's sitting there behind you. You have 30 days to appeal the judgment and sentence of the court.
Bless you. Your Honor, thank you. That's all I have before the clerk.
All right, thank you, Mr. Maddox. All right, anything else from 1:30? All right, 2 o'clock. Have y'all figured out who needs to go first? I think Ms. Dudley, you indicated yours would be short with Mr. Gabney. Do you have a case number off the top of your head there, Ms.?
25 CF 2031 and 25 CF 380. I filed a motion for a furlough. I want to correct one thing. The viewing is actually tomorrow. I put August on there. You should have said July.
I figured it out when I read it.
His grandmother passed away. His family contacted me. I have included the letter from the funeral home about the funeral and the viewing, which is tomorrow. He asked that he can be furloughed in order to go to the funeral of his grandmother. He's amenable to any conditions, including GPS, so that he can attend his grandmother's funeral.
Okay. What's the state's position?
The state would object, Your Honor, largely for two major reasons. The newest charge that he had, it has a 7-year mandatory on it as charged. The original charge that he had his bond revoked on was a fleeing to elude case, Your Honor. And in that, some of the facts that I think are also pertinent is during that he allegedly, the car went airborne, drove through a residential area and almost caused accidents. So because of that, the state doesn't feel, they feel he would be a flight risk in this situation, given that he's already fled to elude officers in the first case and is facing a significant sentence, Your Honor.
Okay. Ms. Dudley, you want to address any of that?
Mr. Goodbye maintains he's going to show the court. This is the case we had a hearing on. We are planning on doing depots and fighting it based on the detention in the case and some other issues with the case. He's just asking the court to put a GPS monitor on and let him go to his grandmother's funeral.
What's the status of the case? I mean, it's been,
We have
this case,
depositions.
the newest case is from October.
We have depositions scheduled on the case for, I believe,
August 28th.
28th, I believe. Then after that, I expect to file a motion to suppress, which is not a surprise based on the body camera. The state is aware of that.
It's on Saturday.
Yes, sir.
When are you asking for him to be released? Because my concern is, how does pretrial services put a GPS monitor on a Saturday?
I would ask that he be released tomorrow and then be returned to the jail on Saturday evening after the funeral. The viewing is tomorrow at 5. And I would ask that he be released at 3 and then return to the jail by 5 o'clock on Saturday.
I guess my concern in looking through his history, and I know he's a relatively young man, but there's plenty of juvenile history that also shows a lot of resisting, which is running, coupled with,
I swear I won't run. I swear I won't.
say again?
I swear I won't run. You could bury me under the jail.
Well, I'm looking through all these cases, and there's quite a bit of them. But all of them show runner, to me. So I'll certainly listen to anything else y'all want to tell me. But my concern is someone with a history of running, currently charged with a case from fleeing to elude, and a case where he's looking at a 7-year minimum for trafficking fentanyl, that not only has he have a history of flight, but now he has reason to.
Your Honor, he's stating that he's not a convicted felon. He doesn't have no violent history. He said he will be here. He has previously fought a case that was actually very serious.
I understand.
He showed up to court. He did everything he's supposed to do on that case.
And turn myself in unwillingly.
Anything else?
Nothing else from the state, Your Honor.
All right, motion's denied.
I think we're set for the 26th.
August 26th.
Yes, sir.
Thank you.
And that's all I have, Your Honor.
All right, thank you, Mr. Edwards. Mr. Owens?
Got Chase Beck. I'm just gonna be quick, Judge, because I'm asking for some more time.
Okay. Like more time from this morning?
I was in another courtroom in another
I'm not giving you any grief, Mr. Owens. I know it happens, and I'm glad you could get here for the afternoon to tell us what we need to do with Mr. Beck.
Well, I think we're close. I don't know that the regular prosecutor assigned to this case is here. I think we are close to a settlement if I could be given some more time.
Okay. Whose case is it?
This is Ms. Bassau's case, Your Honor.
Okay. It's just a VOP, right?
It is.
All right, how much time do you think you need, Mr. Owens? I can give you next week, August 6th, or 3 weeks after that, August 27th.
I'd ask for the end of August.
Okay, and is it for a contested hearing or just see where y'all are at?
I believe we'll have a resolution.
Okay, then I'll set it for August 27th at 9 a.m. without subpoenas.
Now, Judge, he was in the Walton County Jail.
Mm-hmm.
You had him transported over here. I assume he'll just stay here?
I hope so. Usually jail to jail is not a big issue. It's DOC taking people away, even when I order that they stay. So it shouldn't be an issue. Is that case over with over there? Or
It
no?
is.
Okay. Was he doing a jail sentence?
He's got 1129.
Okay, I think they'll keep him here, but obviously if they don't, someone will tell you and you can try to get a move back. But I don't think they'll move him back for that reason. But again, I've been wrong before.
Thank you, Judge.
All right, thank you, Mr.
27th at 9.
8:27, 9 o'clock.
Thank you.
We'll see you then.
Thank you, Judge.
Okay, Mr. Cobb, what did you have still?
I have Kelvin Ford.
That's a plea, right? Well, that's what we're here for. Maybe it's not one.
Judge, this is State of Florida versus Kelvin Ford. History case is on the docket 25 CF 2124, which is a new substantive charge, 24 CF 766, which is a VOP, and 24 CF 765, which is a VOP.
Okay.
I think the state has an announcement to make with regards to the new substantive charge.
Yeah, that's correct, Judge. On the 25 CF 2124 case, the victim is not willing to cooperate, has specifically come by the office multiple times and filled out multiple drop charge requests, and it has given inconsistent statements on top of that. So at this point, the state is not going to be able to proceed in this case. We're going to announce a no pros. My understanding from reading the VOP file is I do not see any technical or other violation. So I believe the VOP is going to be dismissed as well. And I have had a conversation with Mr. Cobb due to the fact that he's been sitting in jail the whole time of whether we could give him credit towards the probation sentence with his jail time, since he wasn't technically, missing anything due to something of his own. It was because of a pending charge. I understand that we don't typically do that, but if he's asking for it, I don't know that I have an objection to it, just because he's in there for about eight months.
This is one of those situations where I'm not going to speak unless you ask me to.
Okay. I'm looking at an order of community control from May 27th of '25, which references back to his plea being entered on April 30th. So April 30th of '25 would be the operative date where he was given 24 months of community control followed by 2 years of probation. So I guess I'll understand what the credit for the time he's been sitting in jail would do.
Well,
If the charge is dismissed that resulted in him sitting in jail for 9 months is null prost, I would ask that he get credit towards that community control for the 9 months that he sat in jail. Or,
So basically just say that his community control would still expire on or about April 30th of 2027.
yes, sir.
The state have any disagreement with that?
I don't know, I don't think so, Judge. And he asked me about it, and I said, I don't know we can do that, but I don't know that that's not a proper way of doing it, to be frank, Judge. I mean, he did sit in jail. He was definitely under community control.
All right. Probation have any input? Okay. I mean, I don't disagree with that. He's been serving basically a more harsh sentence than the one that he was sentenced to, based on a case that was ultimately dismissed.
Yes, sir.
So I think his community control would still expire at that 2-year date from April 30th of '25, and then he'll do his regular 2 years of probation from there. All right, state has announced a dismissal on the new case. That was the sole reason for the VOP, right?
That's the only reason I saw, unless probation has something else I just missed, and,
That was correct.
okay.
It was for the new charge.
All right. Thank you, Mr. Berry, from a different seat than normal. All right, based on that, the VOP will be dismissed as well. Mr. Ford, you'll be basically given credit like you've been on community control since April 30th of 2025. I do need you to speak with probation who's sitting there behind you because you're going to go out onto community control. So you have to make sure that you're following those guidelines, and then hopefully we don't see you back.
Yes, sir.
All right. Any questions or concerns from anybody?
No, sir.
Yes, sir.
All right, thank you, Mr. Ford. Cases are dismissed.
Judge, that's my last case.
All right, thank you, Mr. Cobb. Okay. Mr. Henderson?
Good afternoon, Judge. Tony Henderson for Daphne Quinn.
And I've got her on Zoom. All right, Ms. Quinn, can you hear me okay? You have to unmute yourself.
Yes.
Okay, you can hear you. Okay, Ms. Quinn is present, her lawyer, Mr. Henderson, is present. This is going to be 25 CF 1716. We're here for a motion to dismiss. All right, first of all, has the state filed anything? I didn't see anything.
State is not filing a traverse in this case, Your Honor.
Okay, are you finding that it's a well-founded motion?
We are, Your Honor.
Is that because of the, I guess, consent issue that was discussed in the motion, or?
It was a combination of the consent and the fact that the particular one, you can't upcharge to this one when there's, the underlying battery was not an actual battery, Your Honor.
Interesting issue.
I think that
So if there's consent to misdemeanor battery, but there ends up being an injury that wasn't intended.
Well, and it was also the fall wasn't, there was no intent for anything beyond that, Your Honor, yes.
Okay.
I think it's backed up by video too, Judge.
Okay, obviously, I haven't seen the video, so I'll rely on, obviously, what the state's investigation showed, but, so you're not objecting to the motion to dismiss at this point?
The state is not, Your Honor.
All right. Motion to dismiss is granted.
Thank you, Your Honor.
All right.
That's all I have, Judge.
All right, thank you. Your
Ms.
case has
Quinn,
been
I'll-
dismissed, Ms. Quinn. Mr. Henderson will reach out to you.
Thank you.
All right, have a good day.
You too.
All right, That's the end of our Zoom. All right, Mr. Parnell. Good afternoon. You too.
Judge, I'm here on behalf of Gregory Austin. He filed a bond motion.
Sure. And who's covering this for the state?
I'm sorry, is this,
Austin?
It's with Miss Leone.
yeah, this is mine, Your Honor.
She's not here today. I'm not sure. They've been covering her cases, so I just
Oh, really?
assumed it would be one of the two of them, so.
I was just locating, she gave me notes, Your Honor.
Okay. All right, this is going to be 23 CF 895. Mr. Austin is present with his attorney, Mr. Parnell, Mr. Sheik, on behalf of the state. All right. You're not agreeing to this one, right, Mr.
We are
Sheik?
not, Your
Okay.
Honor.
I just didn't want to go through it all and find
Yes.
out that they had some sort of different opinion.
Understood. No, I put in the motion that Miss Leone.
I had thought so, but you'd be surprised how many times I've heard an entire argument and find out the other side doesn't disagree with it. So I usually ask the other side first, just to make sure.
I try to
Okay.
interrupt if I
All right,
can.
Mr. Parnell, go ahead and argue your motion then.
Yeah, Judge, we are going to stand on the motion as we filed it.
Okay.
With one caveat, Mr. Austin has been in jail on this revocation for 2 years, 7 months. The underlying reason for that, which we address in the motion, is that there was a report that he was in possession of a firearm, which quite honestly was ever substantiated. And also that he was on the internet, and I believe the last time we were before you on bond, we addressed that issue. But I think what I'd like to point out for the time that he has been in, I think he's learned his lesson. And I think 2 years, 7 months might be enough of a punishment at this point to allow him to go back on bond with, the stern warning to walk the line. But,
Well, let me just stop you there, Mr. Parnell, just to make sure it's clear. Revoking someone's bond is not necessarily a punishment. It's not being sentenced to that, but simply a violation of conditions show an inability to file court orders. So he hasn't been punished for the past 2 years, 7 months. I understand it feels like punishment for Mr. Austin, but it's not supposed to be punitive in some way.
Well, and I think your point is well made, but 31 months for why his bond was revoked, I think, could be seen as sufficient time for him to sit and consider the bond conditions that would be reimposed. I guess
Okay.
that would be a better way for me to say that.
All right.
And the other thing that we point out is the family of the alleged victims now, I understand, live in Texas.
Okay.
So there's another reason that, his incarceration, there should be no problem. You're not going to accidentally bump into anybody if they live, 3 states away.
Sure.
And then also, there is the issue of the polygraph that he passed. And we attached a copy of that report. We also sent a copy of that over to Ms. Leone some months ago after it was accomplished. So that would go, if the court considers it, would go to the strength of the case against Mr. Austin. So for all of those reasons, Judge, we would ask the court to reimpose the conditions that were originally in place and allow him to repost the bonds and be released to help me try to get this to the finish line.
Well, let me ask this because, we had a motion to reinstate his bond filed by previous counsel early last year, so 2025. I went back and reviewed the court smart from that yesterday. Just it's hard to take notes that are that sufficient to remember things, a year and a half later, but I went and reviewed that yesterday. And what I had stated is I denied his motion without prejudice to bring it back. But my main concern at that point was that some DCF employees had not shown up for depositions or couldn't be served, even though they're state employees, they should be pretty easy to serve. So I guess let's start there. What's the status of that?
I'm actually glad that you brought that up because we have been trying since October to get those forensic videos, and we did finally get them And it was a week or so ago that we were able to go over to the jail and spend a few hours reviewing those.
When did you receive them?
It's been in the last month.
Month?
Yeah, it's
Okay.
been.
Timeframe is, I don't need the day, but yeah, that
Right,
tells me
it's
something.
been recently. And what I need some clarity on is we need to get those transcribed.
Okay.
But since it was so difficult to get permission for me to look at them as his attorney, do I need another court order to release those to a court reporter to have them transcribed? Because I don't want to send them over and then
Find out you
inadvertently.
violated the
Correct.
order. But that order to release DCF reports and everything was back in May. Why did it
Right.
take so long for y'all to get them?
Well, there was a lot of traffic between your off, Ms. Leone didn't agree to the language of the order that you signed. So we went back and forth for weeks on what the language needed to be. The next one I provided was not sufficient to the state attorney's office, so we did it again. And then you signed the new order, and then it was a few weeks after that that we finally got the forensic video. So it was.
Looks like I signed one in April and then in May when another one was signed, which typically I don't sign them until I get a kind of a thumbs up from the state that they agree with the language, not just the kind of substance of it, but the actual language.
Well, this one slipped through somehow, so it took an inordinate amount of time to finally get those. So we got them, I've reviewed them, we reviewed them with Mr.
Were they not
Austin.
turned over to previous council at some point?
I believe they were, but they couldn't turn them over to me until there was another order since I was the new attorney, and we filed that in October, when that came to where are these videos, because they're extremely important to the case. So we pursued that once we realized we didn't have them, and then there was the April order, the May order. It has just taken forever to get. So I just need some clarity on whether or not I need to have an additional order signed to get these transcribed by a court reporter.
State have a position on that?
On getting that, I can't answer to the specifics on like any of the language that's going to be involved, but knowing Ms. Leone, she would be happily work with you to get that resolved as quick as possible.
Well, so I think I would probably just change the name on the order that was okayed the last time. Obviously run it by Ms. Leone first, and then if that's sufficient to her, then we'll send it to your office.
Okay.
CCing her, so everything is okay.
All right, I just would like this case to make some progress. So
Well-
where are y'all at with the depositions, though?
Okay, and this is part and parcel of that. My plan has always been to get these forensic videos, which we have now. So we have 3 of the male alleged victim, and we have 2 interviews, I believe, of the female. So I'm going to be filing in the next week or so a motion asking the court to give me permission to depose those children. They are in Texas. I'm also going to file a motion to redepose the mother and I'll put in the motion why, but the first deposition was insufficient for what I need. And there are 2 other people that are members of the family that have not been deposed, have been listed as state witnesses that I need to depose. They also were in Texas. So I'm hoping that the deposition of the children, that's going to require a hearing with the court because you can grant it in full, limited, what you have to do. And then I would coordinate with Ms. Leone.
How old are the alleged victims now?
The alleged victims now, I believe the male is 16, 17.
I think the way that statute reads, and I've only dealt with it a couple of times, and it hasn't been recently, talks about the age of the person now, I believe.
I hope that's the way it reads, because then both would be, the female is, 17, 18 years old at this point, and the male would be 16.
I think the way I'm looking at it, it looks like about, the male will be 15 this December, and the female looks like she is already 17.
Thank you for that clarification.
Yep.
But going back one more time, what about the DCF people?
The DCF people, I believe we're still trying to get them lined up for deposition, and we'll get that done quickly.
And why hasn't it been done up to this point?
That I can't answer.
Okay.
We've just, our focus, I think, has been to get these forensic videos, so I have something to ask those people specifically about the way, the manner, and the questions that were actually asked. There's one other, I'm also going to be asking permission to redepose Detective Garrett, who's now retired. But in my mind, once we get these depositions completed, then discovery is complete, and we should be able to resolve this case. There's one other issue and everything.
I'm just trying to go back through the history of it a little bit. Let's see. All right, what's the other issue, Mr. Parno?
We are trying to get some medical records that would be pertinent to Mr. Austin's case, and from 3 different providers, and we keep hitting walls that if he was able to be released and take care of these himself to aid us, it would probably speed the process.
His own records?
Yes.
You can't just do a written release on those?
You would think it would be that easy, but it's not.
Do you have anything as far as correspondence from some provider that says they refuse to give it to you?
It's not refusal, it's really more of kind of a runaround. It's trying to get the right form. One of these is a national drugstore chain, and so we have to go through national to get it released at the local, and it's just, it's a mess.
Okay.
And then, once we get the form, we have to get, Mr. Austin to sign it and then provide it, and then there seems to be something that happens when we do that.
Okay. And just trying to focus on each individual issue.
Yes, sir.
That doesn't really move the court too much as far as forms that need to be signed. I understand the seemingly delay as to the orders, but you filed your motion to get the DCF records in October. And then I signed an order April 28th of this year, and then I guess Ms. Leone from the state had an issue with the language of that. But what was the delay from October to April? I mean, it wasn't set for a hearing, was it?
No.
Okay, I don't always have complete recollection on every
Yes,
case
sir.
until we kind of get here.
There wasn't. When I got on this case, it's a bit like drinking out of a fire hose. It had been around for a while. I think we're up to 10th or 11th amended discovery. There's lots of video. There are transcripts that we were having to get from the other attorney's office. It just took a while to get all that information, and then, what are we missing? And I kept saying, where's the forensic video? And so that's when I finally reached out to Miss Leone and said, this was addressed in October. Why do I not have it? And she was like, we don't like the order. So I provided an order, you signed it, and we still, when you gave 10 days for the state to provide it, and I'm like, where is it? And, I've talked about filing an order or motion to compel, and that's when she said, we need better language. I'm like, well, tell me what the language is. I provided an order. That wasn't good enough. Finally, she and I got it worked out. We got the language correct, and you signed the order, and it was some weeks after that that we finally got the videos. And then, like I said, they're rather, long, so I watched them. Then we went over a week or so ago, 2 weeks ago, and watched those videos with Mr. Austin. So at that point, it's like, now we need to get them transcribed and then get the depositions, these other motions filed that will hopefully allow us to depose the folks in Texas. And then just a couple of other depots here, and we should be ready to go in those medical records. And I didn't mean to, it'll be easier for him to sign those records. It's just, if he could pursue his records and directly, it would speed the process up.
I guess my issue, and I think I brought this up in previous hearings, is that he was initially released after given a total of, about $200,000 cash or professional bond in April or so of 2023. And then he was alleged to have violated it, I want to say it was December of that year, right? Yes, December of 23.
Yes, Your Honor.
And, which was more than a year before I took over this division, I believe. So I always have to go back and kind of reread the things because I don't have any independent knowledge of it. And the issue was regarding him using a phone or potentially carrying firearms. And I know there was some concern about whether or not that was truly proven in some way. But again, that was before my time on the case, and I'm not saying that matters other than I don't have any independent recollection of any kind of hearings without going back and watching literally every single hearing he's ever had. I'm not even sure I can go back that far without getting kind of archive access to it.
We addressed that issue
Sure.
at the bond hearing that we had.
And so my issue is, it went by so far, and I think there was some sort of, there was an affidavit or something I think I reviewed in the court file, or during a court hearing, but I don't think it's in the court file. And that's what I'm trying to remember, because I don't see it here. But in discussion of that, so that happens, and then over a year goes by from that revocation of his bond until there's a bond hearing to reinstate for some of the same reasons that you're bringing up. And I think I entertained it in February of 25.
I believe the bond hearing was January 30th of
January
2025.
30th. I knew it was January, February. So January 30th of 2025, I had the hearing where I reviewed everything, but my big concern at that point, which is why I specifically said, and again, I had to review this myself yesterday, and I have got the advantage, I can go back and listen to things that y'all don't have access to unless you submit a form and get a CD and all that stuff. But I went back and in my notes from reviewing it yesterday is that I denied it without prejudice to make sure those depositions got done, because that was my big concern at the time is, was discovery proceeding? And it seemed like at that point, the issue was that these witnesses were not available in some way, whether they couldn't be served or they weren't showing up. I think it was an issue with them being served somehow. So my kind of decision to say it was without prejudice was, we talk about this all the time with bond hearings, that I can't re-entertain bond unless there's a substantial change in circumstances. But with that particular issue, my point was to say, I want to know if there better be a change in circumstances, because these people need to be deposed. But obviously they still haven't been, but I'm not sure where I can really lay the blame for the delay at this point, at that time. And I'm certainly not trying to assign blame in the way it sounds, but just, but there was a change in lawyers for Mr. Austin, which means a lot of things don't necessarily start over, but you've got to catch up to speed. And that's why I had the question, and I'm looking at Mr. Sheik, who's looking at me like, well, I haven't been a part of this case either. But to understand, did previous counsel have access to those things? And then why was there a delay in getting it to you other than that order? But I don't see a reason for the delay of that order other than it wasn't given to me and then the language had to be changed for some time. And I'd like for these cases, these depositions to be done. I understand you want transcripts now in order to potentially question the DCF people as to what was done during the course of those interviews. And it's hard to impeach or question someone with a video as opposed to the transcript, so I understand where you're coming from, Mr. Parnell. But I'm not sure if that's really changed anything. If you were telling me the same thing, and it was a problem that we can't get these depositions, they won't do them, they won't give us a date, we can't get the people here, it doesn't sound like that's a continuing issue, at least at this point, because you've had to do other things. And the only thing I can really see, potentially attribute to the state is maybe the time from the April order to the May order, changing that language, and then, so that's about 4 or 5 weeks. And then once I issued the order, it took more than the 10 days I initially provided. And then how long after that late May date did you actually get those recordings and DCF records? And it sounds like, from what you said, about a month later. Am I wrong on that?
I'm just working on memory. There's been so much that has been sent over, but I can assure you of this. After we filed that in October, we're still getting, because I think I got on this case in July of 2025.
Okay.
And so by October, we had a hearing or something, you're like, get that motion to me and we'll get the order signed. So we're receiving all this other discovery, and at some point, asked my paralegal, where are these forensic videos? Because I know I haven't seen them. And he's like, we haven't gotten them. I'm like, why not? So anyway, that's when I started having an email back and forth with Miss Leone trying to get these, and I provided an order that you signed.
Honestly, it may not have been her at that time. Right?
And I'm not trying to throw her under the bus, I'm just saying.
Well, no, what I'm saying, the reason I'm saying it is it may have been a different lawyer at the time that you're talking about, because I don't think she took over CAC cases until January.
That is correct.
So
there's
that may-
that change. But I just want to assure the court that, once we found that these videos had not been provided to us yet, despite the filing of the motion, then we started pursuing it vigorously. And I've got emails, back and forth over weeks and months trying to get this. So we've pursued it. We finally got it. We watched them. We got over to the jail to watch them with Mr. Austin. And we know the people that we need to depose, and they're all rather related to these forensic videos that we need to get transcribed. Which brings me back to that question of, do I need to provide another order to, once we figure out who is going to transcribe these?
Get back to that order. I think specifically the order, the amended one from May 29th of this year, states, in order to protect the protected health information of the victim in accordance with, I'll just say federal law, because it's a lot of numbers and letters. It is ordered that the defense counsel is A, prohibited from using or disclosing the protected health information of the victim for any purpose other than the litigation or proceeding for which the information was requested. So I don't think so, but I think a worded letter from you, Mr. Parnell, to whoever your court reporter is, that these are not to be disclosed to anyone, or remain copied, and anything that she receives, I say she because most court reporters are female, I don't want to do that, but that the court reporter, if you give them anything, that he or she return anything that you give them without making any other copy of them. But I think that still falls within for the purposes of litigation.
Very good.
So I don't think that will delay us anymore. Obviously, motions regarding depositions of underage alleged victims. I think we still have to have that, but again, I think that depends on the age that they are at the time of the deposition as opposed to at the time of the offense. I could be wrong on that, but from my reading of the statute, that's what I think it is, because I think it's come up in previous hearings I've had months ago on different cases where we had to talk about what their age was at the time. That's a relatively new law, obviously. So we just don't deal with it very often.
I had to read it.
Yeah, I try to reread things every time I come across them because they get changed, and even though I think I am as about as diligent as I can as far as reading case law updates and statutory updates and rules of procedure updates, sometimes things happen and you miss it. So that's why we try to reread them every time, but, so we'll deal with that, but when it comes down to it, I don't see any of the court's concerns from the previous bond motion as being something that's causing the issue now, and to kind of somewhat relitigate something that happened 2.5 years ago, the motion to revoke his bond, or the courts, I don't know, was there a motion to revoke bond, or it was just sua sponte by the court based on pretrial services providing the information, I think. So there wasn't a hearing on it, but it was decided quite some time ago, and so I don't see why the bond was revoked in the first place is something that really hasn't changed. So what is the change in circumstances? And that's why I specifically went back and listened to it to find out why I hadn't granted it, and did I give kind of this foothold to potentially come back with that particular issue. Now, I know there's some somewhat other things have been argued as far as the polygraph, which I reviewed, and not to say I would do anything differently if I had all the information, but I think in the motion when I read it, in the report by the polygraphist, sorry, I was going to say polygrapher, that didn't sound right. He refers to himself as a forensic clinical polygraphist. It doesn't seem to really indicate, I mean, there's some redactions here, which are certainly good if they're going to be filed in a court file. But there's some information potentially missing as to what questions were actually asked and how they relate. But again, as you've noted in your in your case, in your motion, that it's not admissible evidence. So at trial, but what am I to take from this? This is not a situation where you're providing a report. The state doesn't have an opportunity to really look into it more than what you've provided, other than what the polygraphist has provided without any way to question him as to what was actually said. Typically, correct me if I'm wrong, Mr. Parnell, it's been a while since I've dealt with a polygraph, but they usually videotape it. So how do we know what was actually said versus what this person said it was? How do we know what their findings were other than what they say they were? And there's not a chance to cross-examine them in any way with something that innumerable times has been decided is not admissible. So how does that really move the court as well? And I just don't think it does. My biggest concern in this case from a bond standpoint is how long it's taken. And that's why I focused on what were the delays to get us here, or not get us here, because we're in this position now where this case has been going on for over 3 years, and has not been resolved. Again, it's not an assignment of blame, but it's just, what are the reasons why? And my biggest concern from the beginning was, why aren't these witnesses being deposed? And now I'm not hearing anything as far as there's been some sort of roadblock to that, other than, I mean, it'd be nice to have these transcripts, but I don't see it where I can say the state has done something so dilatory as to change previous court rulings.
What the roadblock has been is just getting the forensic video. Now that I have those and have been able to review them with Mr. Austin, now we have a plan going forward of filing to, well, first getting them transcribed, which hopefully will be a matter of weeks. And then, in the meantime, also filing the motions to get the court's permission to depose the children and redepose the witnesses that I feel like we need to.
Well, I guess the one thing I would suggest, Mr. Parnell, is kind of look at this as a multi-lane highway here of numerous things that can be done at the same time. And I think that's part of the issue is when there's a roadblock that stops you from doing one thing, are the other things being done too?
Yes, they are.
And so at this point, I don't want, let's get the motion regarding any minor child alleged victims heard. I'm assuming, have you talked to Ms. Leone? Is she disagreeing with that?
No, not at all. I mean, we've been talking for months about.
Not about the hearing, but about letting you do that, those depositions.
We haven't spoken directly about that, but we've spoken about going to Texas to depose them, so haven't gotten a direct no problem, but we've already discussed going to Texas to do these depositions, so.
So I think making sure those are done, and as far as repeat depositions, again, let's have all those hearings as soon as possible, so we're not, for example, waiting on transcripts before setting those. And, I just want to make sure that every rabbit trail that needs to be run down is somewhat being done at all times.
Well, I've already started drafting the two motions for each individual child, because there are different statutes that may cover each. So I've got kind of a donut hole there that I just need to fill. That's why I said I think in the next week or so, I should be able to get those motions filed. The motions to redepose these witnesses are pretty standard, so those shouldn't take any great amount.
Sure, and I understand, and that's my point, is the only thing we're really waiting on at this point are these transcripts, but you know how long that's going to take.
Weeks, I'm hoping.
Hopefully less, but in the meantime,
I was waiting for the videos.
getting everything set up so you're ready to do it. I mean, because it's not like you can't prepare without the transcripts, right?
True.
You can prepare with the video. It makes it easier, but so get the deposition set as quickly as possible. So once the transcripts are done, you're not then waiting 6, 8, 12 weeks or whatever it might be to get those set. Because what I haven't seen up to this point is anything that's really changed that I can say is the state's fault in whatever delays that have been, short of you handed me a stack of emails or phone records that show, not even phone records, but I've tried to attempt to do this many times, I'm not getting any response. All I've heard is just, we've asked for things and we've got them, and there was a delay in an order, and then we got them, and now we're trying to get them transcribed. As a sufficient reason to almost sanction the state for its delays.
I'm not asking for sanctions. I just want the court to understand that we have diligently tried to get these forensic videos from back in the spring,
Well, and the reason I bring it up is because I don't think there's enough reason to reinstate the bond based on what's happened or time that he's spent in jail. But what I'm looking at is if I feel the state is not doing its job in a timely fashion to the point that it's prejudicing a defendant, I may say, you know what, state, if you wanted to keep this defendant incarcerated while this case is pending, you should get your job done faster. And I don't see anything to that effect at this point. So that's why I'm focused on that part, is because otherwise, we're talking about why his bond was revoked 2.5 years ago, and just trying to say, well, isn't that enough of a punishment? And again, I don't think it's a punishment, but other than there were orders, they weren't followed, previous court made that decision, it wasn't attacked in any way for over a year, and now we're 1.5 years after that, to the point where now we're still bringing it. So I don't think there's a change in circumstances warranting a bond reinstatement at this point. The reason I'm focusing on what's been the delay is, am I going to tell the state, if you don't get these things to him by a certain period of time, I'm going to entertain bond again, because I don't think it's fair to people to sit in jail for 3.5 years because the state's not pursuing things quickly enough. I don't see that as the issue at this point. So because of that, I'm going to deny your motion.
Thank you, Judge.
And I can tell you, I have in other cases done that. And frankly, I've granted Richardson hearings on issues where I felt the state didn't provide things in a timely fashion. I've done those things, but I just don't see any reason to really do that at this point.
Thank you, Judge. Well, I'll have those motions filed, and then we can get the hearing set. And-
Certainly, as quickly as you can get them, just contact the state, get dates, and the clerk can set those. If they're contested for we have typically at least 2, sometimes 3 motion dates a month.
Okay.
And we can always, pencil you in as fast as possible.
Well, hopefully, Ms. Leone and I can talk, and if she doesn't have an objection, then that should make those hearings much quicker.
And I've made myself known pretty well. I say this to you because you don't practice in my court a lot compared to the state attorneys who are here almost every day, is I know what the statute says, but I think there's some argument about the confrontation clause and that it's a trial right, not a discovery right, but I think giving everyone the opportunity to discuss things with witnesses is a very important part of due process.
I appreciate your opinion on that. I would agree.
And I think the state knows my feelings on that from previous hearings. So just to give you the benefit of prior rulings of this court.
No, I appreciate that, and we'll get those filed, and hopefully we'll be in a position to resolve this case as soon as we get those done.
I hope so, too. All right, thank you, Mr. Parnell. Thank you, Mr. Austin.
Good to see you.
You, too. All right, Ms. Rivers or Mr. Williams, what else do we have?
We have one out of custody, Your Honor.
Oh, Ms. Bailey.
Just didn't want to proceed.
For the judge.
Right.
Yeah, it's good to see you.
Good to see you.
Is Ms. Bailey here? All right. My understanding, well, I'll keep it to myself. I'll talk to you about it later.
I have one that's out of custody, Your
Okay,
Honor.
come on then.
That would be Larry Miller.
Mr. Miller. This is the motion for sanctions, I believe it is?
That's correct, Your Honor.
It's only filed in one case, is it? Or no?
That's correct. I don't believe, I don't know that if Mr. Russell had filed it in his, but if the witness is stricken from the record in this case, I'm sure that.
That witness is potentially a Williams Rule witness in the other, from I remember y'all
That's
talking about
correct,
these
Your Honor.
cases before.
That's correct, Your Honor. And when we were in court previously at the last pretrial conference,
Cannot find it.
the state, Ms. Basso had indicated to you to leave this set for today, and that if she had not found him and provided us with that information, that this would be the appropriate remedy. We have received no updated information regarding the location of Edgar Batson. We have set depositions multiple times.
Excuse me.
Each time back in 2025 and again in February of 2026. Each time the return of service list, Mr. Batson could not be found, but the state wants to call him as a witness and has indicated reasons that he absolutely would be a witness in the case. And We've given council multiple opportunities to provide updated address. They still have not. And we're asking that the court give them a date where they must provide the address, or in the alternative, that the court would strike Mr. Batson as a witness from the state's.
Who is the witness? I understand what his name is, but, excuse me.
I'm sorry.
Who is the witness?
His name is Edgar
Oh,
Batson.
I'm sorry. That's what I was trying to say before I started coughing. I understand what his name is, but what is his relation to the case?
He's a witness for the state that's supposed to be against my client.
Okay. Okay. I'm trying to read through even the initial arrest report in the 24 case where the motion's filed. I see his name listed as a witness, but there's nothing in the narrative that says who he is or what he knows. So, Mr. Sheik, I know this is not your normal case, but you're the state for the purposes
Yes,
of
Your
this
Honor.
case in this hearing. Do you have any notes that indicate,
Well,
can you find Mr. Batson or not?
I can say this, Your Honor, we have had our investigator on this to attempt to locate and has been unsuccessful. And they have been, unfortunately, we have no additional information to be able to provide regarding an address for this witness.
We would ask, Your Honor, that he be stricken from the state's discovery exhibit at this time.
Mr. Sheik, do you have anything to understand who this person is and what they may be testifying to?
As far as their specifics, I don't have anything on what they would be testifying to. We would obviously object to them being stricken. However, we understand the court may have to do it based off of the information that we have.
And Ms. Basso indicated to the court previously that if she had not been able to find him by this date, that she would not object.
Okay. What I'd like to do is was that the June date that we just had where she said that?
That's correct, Your
Yes,
Honor.
and actually, Your Honor, I apologize.
Go
I should, my notes here, she doesn't say to object. She said leave it to the court for their opinion, which is a substantial difference.
Okay. All right, Ms. Rivers, if you'll send me over an order granting your motion, I'm going to still review that last date just to make sure I'm hearing exactly. I didn't do that for today because, frankly, I didn't have any recollection of it as far as those details of it until you just brought it up. But you know me, I always go back and re-listen to things just to make sure, but.
And Your Honor, we had approached and we were at the bench.
Well, just for everyone's knowledge, when you approach and I turn on the white noise, everything is still recorded and quite clear.
I'm just letting the court know that that's where the conversation occurred. It
Okay.
wasn't here.
And I'll listen to it again just to make sure, but if the state isn't objecting other than to make the court make the decision, I'll listen to exactly what was said. Again, I haven't heard anything about how vital this witness may be, that he's somehow the linchpin of the case. I have no idea his involvement other than his name is listed as a witness.
And the state, I don't believe the state ever told you
Okay.
that.
And frankly, it's strange to read through an arrest report and see someone's name listed as a witness, but then not see their name in the narrative anywhere. But and he's listed as being born in 71, so he's obviously not the minor, one of the minors involved
No, Your Honor.
in any way.
He's the brother to the alleged victim. He's one of the brothers.
That's right. Because according to the information, these acts happened somewhere between 1989 and 1992. All right, send me your order, Ms. Rivers.
Thank you, Your Honor. Twenty-fourth?
What did you want to do with Mr. Russell's case?
Say who?
Mr. Russell's case was on here as well.
Oh, just make sure they're all on the same dot. What are they set for August?
They're both set for the August pretrial.
August 24th?
Yes, sir.
Yes. The motion was only filed in Ms. Rivers' case, I believe.
This is Melinda Settle before the court on 25 CF 1745, 25 CF 1486. Your Honor previously had declared her incompetent to proceed, and she has been sent back from Florida State Hospital.
Okay. And I've reviewed that report that came back from them with her return. Is today to be the competency hearing then?
Yes, Your Honor.
All right, does the state stipulate to making that decision based on the report?
Yes, Your Honor.
Okay. I apologize, let me just bring it back up. All right, and that report was filed on June 11th. Settle was transported back. I reviewed the report again yesterday. It does opine that she is competent to proceed based on the stipulation to doing everything based on that report. I will find that she is, in fact, competent to proceed at this time. What would you like to do with the case now?
Your Honor, I did mention to Mr. Mull that we never got score sheets in this case, and I would like to be able to get score sheets to be able to go over that with her. We're going to ask to have her on the very next docket day. Pretrial conference day, so 8/26. We would ask to leave her on for then.
Mr. Mull, do y'all have guidelines?
Well, here's where I'm kind of at, based on what I'm seeing. I had one of the cases was open, the other case wasn't even opened. I have no score sheet, no notes, no nothing in either one of them. So I'm going to have to basically do the intake onto it. I'm assuming because somebody knew that she was not found competent and just stopped right where the progress was. So it's probably been a closed file, and that's why I only have one open and the other one's not open. So I would assume we'll be able to get them both open, and I should be able to get an offer over to the defense. I'm hoping by next week, but I never know how 1 week's going to go from week one to the next. It'll definitely be over to her before the 26th, I can tell you that.
All right, well, if you could send me the order on her competence, I'll sign that, and then we'll see her back on August 26th at 9 a.m. If for some reason y'all can get it figured out before then, bring it back.
Yes, Your Honor.
If someone had said this without clearing it with everybody, but I maybe open up one day, maybe around the pretrial detention docket on one of those Thursdays, not next week, because we have a miscellaneous date, but the two after that, because I've got some free time due to civil cases going away, that I may open up for things that may need more time than just a pretrial detention in 5 minutes. So if you get it worked out, we can potentially bring it in before August 26th.
Yes, Your Honor.
All right, thank you.
Okay. Be back out once I know some more, okay?
I'm going to suggest Nichols first. largely because that's what I've got out in front of me. Judge, I've been conversing with the state attorney all day today. They're largely in agreement with me on my motion. The difference of opinion is whether or not
Based on the
they
dance
have-
that Mr. Sheik just did behind you, I'm not sure. That's 100%.
Well, I'm not
The
saying it's
first
100%.
part one, yes.
Where I think we're still having a difference of opinion in is how much the state has to prove in order to show that it's a deadly weapon. I did obtain photographs of the item. I provided them to the state. The state filed a reciprocal on it. Do you object to me?
No, that's fine.
It's actually more in the nature of a cleaver, Judge.
Okay.
Which is basically what my client had said last time we were in court. Certainly not a dirk.
A dirk is like a
It's a stabbing.
stabbing, almost like an ice pick type thing, right?
But there were a couple of cases that just dealt with whether or not, for example, a steak knife was a dirk, and so that's sort of become a thing in these cases, I think. I've read the state's response.
Definition, a short dagger of a kind formerly carried by Scottish Highlanders.
I'm guessing that wasn't the court's definition, Your Honor.
I don't know if you have
AI?
to prove someone was a Scottish Highlander or
Yeah.
not.
In any event, Judge, what we're left with is what the state has to prove on it, whether or not they have to prove it was used or intended to be used as a weapon. What the state primarily cites is this Moore case. Moore is a first DCA case from 2005, prior to the statutory revision. Moore has to do with a pellet gun, and the real thrust of the case is that the trial court had read a jury instruction that said that the state had to prove it was a pellet gun. Didn't contain the phrase deadly weapon. And in what I feel like is dicta, the state says, although the trial court did provide jury a definition of deadly weapon, the definition given, which contemplates the use or threatened use of the object, is logically inapplicable to a situation, which is different than what the actual jury instruction says. And the reason I say it's dicta is because when you read the case, after what it has to do with is the state or the court's instruction that essentially a pellet gun would suffice, and there needed to be no additional proof with regard to that. The state also cites Nystrom, which I cited in my motion, and particularly referenced the court to footnote 4, which sets forth a list of scenarios where otherwise innocent items would be deemed as a deadly weapon simply because they were capable of being used as a deadly weapon, and talking about how inappropriate it would be for someone to be arrested for what was otherwise innocent activity. The case that, the other case that I cited was this KRV State, 299 Southern 3rd, 1121 from 2020. And it was having to do with a 4.5-inch bladed steak knife that was at the bottom of a backpack, and that the testimony was that the child had been fishing and using the steak knife for fishing. In deciding the case, they quote Nystrom and reference that same footnote and hold that, let me see if I can read it. Furthermore, an object can be considered a deadly weapon if, 1, its, quote, sole modern use is to cause great bodily harm. Now, in my motion, I omitted the citation, but I have a copy of KR if the court would like to see it. Or the accused used or threatened to use the object in such a way that would cause death or great bodily harm. Now, the state and I have talked more about this. It may be that this is one of those things the court's going to have to see what the actual evidence is at trial, or it may be something that's better argued as part of my JOA at the close of the state's evidence, something along those lines. One thing is I've spoken with the state and explained to him Mr. Nichols' situation and asked them to seriously consider a plea to a supervisory sentence, community control or probation. The state attorney's indicated to me he's going to take a serious look at it over the course of the weekend and will let me know long about, I guess, Monday or Tuesday. But certainly, I think that the court now knows we're not talking about a butcher knife. We're not talking about any of the enumerated items under the statute, and so it's going to have to be shown to be a deadly weapon. The state's relying on language that is not in the jury instruction, that basically if you could cause serious harm to somebody, that'd be good enough. If that were the case, then carrying a corkscrew would be sufficient. In fact, the belt that an individual wore would be sufficient because you could use that as a garrote and strangle somebody with it, or if it had a heavy metal buckle, you could use it to beat them half to death with it. The shoelaces could be used as a garrote. It seems that there simply has to be something more than what you could do with it. There has to be something showing that it's not in its ordinary use. And frankly, Judge, the ordinary use for a meat cleaver is to cut meat. The testimony at trial, I anticipate, if we get to the point where we put a defense case on, is going to be it was in fact used, and I'll have already listed witnesses to how it was used and the fact that it was used at a barbecue that day to cut up meat.
All right, so just to kind of run this through.
Yes, sir.
He's charged with a violation of 790.23, right?
Yes, sir.
Which states, paragraph 1, is unlawful for any person to own or to have in his or her care, custody, possession, or control any firearm, ammunition, or electric weapon or device, or to carry a concealed weapon, including a tear gas gun or chemical weapon or device if that person has been convicted of a felony. We'll then go to see what concealed weapon means under 790.001. And you argue all this, Mr. Williams. I'm just kind of talking it through. Concealed weapon under 790.001 4A states concealed weapon means any dirk, which we've talked about as being more of a dagger.
Yes, sir.
Metallic
Stabbing
knuckles,
instrument.
billy, tear gas gun, chemical weapon or device, or other deadly weapon carried on or about a person in such a manner as to conceal the weapon from ordinary sight of another person. So we're clearly then talking about, as far as the definition of 4A, concealed weapon is that kind of last part, or other deadly weapon carried on or about.
Yes, Your Honor.
And so just because something can be used as a deadly weapon, does that mean it is one? Because even when you read paragraph 20, just the definition of weapon in 790.001, it says weapon means any, again, dirk, knife, metallic knuckles, slungshot, billy, tear gas gun, chemical weapon or device, or other deadly weapon except a firearm or a common pocket knife, plastic knife, or blunt-bladed table knife. So weapon does mean knife, which, is a meat cleaver a knife?
Well, Judge, the point of the original motion and where the state seems to be in agreement with me on it is that weapon definition is not appropriate in this charge. It's the concealed weapon definition. And that's,
But
I've not
doesn't-
gone into that a great deal today because we seem to be in agreement on that.
But concealed weapon means, among other things, a deadly weapon carried on or about a person in such a manner as to conceal the weapon from the ordinary sight of any person.
Yes,
another
sir.
person.
We're back to deadly weapon.
But the definition of weapon includes a knife. Is there a definition of deadly weapon?
I'm unaware of one besides
The jury instruction.
the jury instruction.
Which
Your
states a deadly weapon is any object that will cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. The ordinary and usual manner of a meat cleaver is to butcher meat.
Yes, Your Honor.
So, I would say that the ordinary and usual manner contemplated by its design and construction does not make a meat cleaver a deadly weapon for purposes of what we're talking here. It's not a weapon being used in a deadly manner. It's whether or not a weapon that has other ordinary and usual design, that's contemplated to be used for other things, does not mean this. So I tend to agree with the defense here that unless there's some, I guess the issue is there some evidence that it was being used in such a manner?
Well, and in
does that
that,
even
Your-
really matter?
Your Honor, I don't believe that that's necessary in that it has to be used or threatened to be used. In fact, whether or not it's dicta or
Tell me a
not.
statute that says
Well,
a knife that's not being used in a way that could hurt somebody is a deadly weapon.
Well, the various ones that were provided by the defense and by us both say that that is a determination. If it's a knife, which I would say a cleaver at least falls into the category of a knife, it would be a decision of an issue of fact left for a jury, and I would have to
But he's
argue
not
that.
asking to dismiss the case.
I understand, Your Honor, but all I'm asking for is that we use the definition, a deadly weapon is an object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. And that's all I think we should put in there, because it says an object not designed to inflict bodily harm. That's a separate thing, because I don't believe it's applicable in this case, because you can't show somebody concealing a weapon to be used or threatened to use. And that's what I think, whether or not it's dicta or not, I don't believe that factors into this case, and it's given only if applicable. Well, there's no use or threatening to use, so I would have to argue that would cause harm in the ordinary and usual manner contemplated by its design.
But what is a meat cleaver designed to do?
It's designed to cut meat and flesh and bone, Your Honor. It's the same thing.
Of meat in your kitchen.
Yes, but similarly, a gun, and I know that's been enumerated separately, but most objects.
It's an exception for a reason.
But, yeah, but I agree, most objects that we have, an axe is designed to chop down a tree.
Okay.
But I would argue that you have a concealed axe, that's a deadly weapon that's concealed. And that would be my argument in front of a jury. Because,
Judge, has anybody here ever been camping?
So if someone who's a convicted felon decides to go camping in the woods, and they want to carry a small hatchet or axe with them, they have to carry it in an open fashion? Is that what we're prepared to say the law
Well,
says?
what it says in most of the cases is that it is a fact-specific thing. And I think in those particular cases, you're talking about someone who's going to out camping, which would be a fact that would be involved in someone making a determination in that particular case. Here, he's outside of a store. in a public with many people around with it concealed inside his pants.
Judge, he is walking down the sidewalk. If you're walking down the sidewalk, you're probably going to be near some business or another.
All right,
But
this
that's
is what
also
I'm
how
going to
you
do
get
at this
home.
point. I'm going to go through and reread the case law. I'll issue a written order by next week. I know y'all are contemplating some sort of other resolution. You can certainly make that decision if y'all come to an agreement on how you want to resolve the case. Unless I think it's completely absurd, I expect I would accept whatever plea y'all come to. But I want to read through it now that I've heard the arguments, and kind of go down, like I said, these kind of rabbit trails of differing definitions, especially because it's a situation where there's not a statutory definition of deadly weapon, but there is a jury instruction that doesn't seem to be based on a statutory definition. It's, how do I use that definition to explain what the law is to a jury if there's no statutory basis for it, other than it's a factual issue for them to determine, but I need to instruct them on the law.
Yes.
And so I understand both sides of the argument. I'll go through and read it based on what y'all have argued here today, and then I'll issue an order, hopefully, certainly before we have a pretrial, but it would be my intent to get it to you next week.
Yes, sir.
If
Thank you, Your
my
Honor.
civil calendar allows.
Yes, sir.
Guess it depends what time we finish up here today.
Yes, sir.
All right.
Yeah, we've got Crivic. Same thing.